President, please be seated. The court is now back in session. The trial chamber next invites the parties to make submissions on the order of the presentation of evidence with an aim to maximize the efficiency, logistics, and coherence of the proceedings through a clear trial structure. The co-prosecutors have proposed that case 002/02 be divided into 5 phases. That is, role of the accused, security centers, treatment of targeted groups, work size and regulation of a marriage nationwide. That is document E305/6. The co-prosecutors have proposed the following order of trial. S21, internal purchase, role of the accused, JCE witnesses, Trump Cooperative, Krang Tajan Security Center, O Consign Security Center, Phnom Krau Security Center, genocide of Vietnamese, genocide of Cham, First January Dam Worksite, Trapeng Thmo Dam Worksite, Kampong Chnang Airport Worksite, forced marriage, and overview. The lead co-lawyers have proposed the following order of trial. S21, internal purchase, role of the accused, JCE witnesses, Trump Cooperatives, and Krang Tajan Security Center, treatment of Buddhist, treatment of Vietnamese, treatment of Cham, movement of population phase 2, as it relates to the treatment of Cham, First January Dam Worksite, Trapeng Thmo Dam Worksite, Kampong Chnang Airport Worksite, Okansai Security Center, regulation of marriage, and experts. That is document E305/7.1.4. The trial chamber invites the defense teams to comment on these proposed orders of trial. Each team has no more than 15 minutes. And first, I'd like to give the floor to Noon Chia's defense. You may proceed.
Thank you, Mr.
Please wait. Defense counsel, please wait. I think there is one issue. Bạch Ong, you may proceed. Bạch Ong, to your honors, I apologize for my interruption. In order to avoid the order of trial proposed by the lead co-lawyers for civil parties, we would like to briefly mention the notion behind our request for the proposed order of trial, and we would like to seek also comments and remarks from other parties. I understand the importance of the role of the co-prosecutors and their proposal for the order of a trial. And I believe it is not necessary for other parties to remark on the order of trial proposed by the co-prosecutors. President, thank you for your observation before the floor is given to the defense. And now the defense for Noon Chia, you may proceed.
Thank you, Mr. President. Concerning the order of presentation of evidence, we note that the prosecution's and lead co-lawyers' submissions on the different topics that would be heard at trial are based upon the witnesses, civil parties and experts they propose to call in case 002/02. We have requested to call several experts and witnesses concerning a topic that is not among those already proposed by the prosecution and the lead co-lawyers. And that is the existence and character of an armed conflict. The trial chamber has included this topic within the scope of case 002/02 as part of the general factual findings that will be disputed in the trial. It is in fact the only topic among the general factual findings that has not already been heard in the case 002/01 trial. Mr. President, it's our view that the question concerning the existence and character of an armed conflict is an essential contextual topic, especially since we will argue that there existed an internal or non-international armed conflict in parallel to and intertwined with the international armed conflict. The relevant facts in relation to the existence of an armed conflict fundamentally affect the arguments that the parties may put forward in relation to numerous crime sites and crimes, most particularly in relation to the S21 Security Center and the internal purges, which both the prosecution and lead co-lawyers have proposed as the first two topics to be heard at trial. In addition, it is at the very heart of our theory of the case. Therefore, we submit that it is logical that the topic of the existence and character of an armed conflict in the period of 75-79 be the first topic addressed in case 00/2 trial. Following the existence of an armed conflict, that matter, we would concur with the prosecution and the lead co-lawyer's proposal that the next two topics to be heard should be the S21 Security Center and the internal purges. For us, these topics are also essential to our theory of the case, so much so that the majority of witnesses, civil parties and experts we have requested have been requested at least in part for their ability to testify in relation to these very topics. Unlike either the prosecution or the lead co-lawyers, the next topics we would propose to be heard at trial are the genocide of the Vietnamese, then the genocide of the Cham, and then the Kampong Chhnang airport worksite. We submit that these topics are interlinked with and build on the topics of the armed conflict, the S21 Security Center, and the internal purges. The charge of the genocide of the Vietnamese will be affected by submissions in relation to an armed conflict with Vietnam, the treatment of the Vietnamese in the Eastern Zone, and our submissions concerning Vietnam's long-term aggressive posture against Cambodia in general, and democratic Kampuchea in particular. The charge of genocide of the Cham will be affected by submissions in relation to internal disturbances and sabotage actions in the Eastern Zone, which we will discuss during the trial segments on the S21 Security Center and the internal purges. And the charges relating to the Kampong Chhnang airport worksite will be affected by submissions concerning policies responding to internal enemies within the Revolutionary Army of Kampuchea, also to be discussed during the trial segments on the S21 Security Center and the internal purges. Therefore, Mr. President, in our view, it would seem logical that these topics should be the next to be heard at the second trial. We also submit that the topic of the role of the accused and joint criminal enterprise be the last topic to be heard at trial. This is because it is our view that party submissions concerning the topic depend fundamentally on the submissions made concerning the facts relating to the other crime sites and charges. Thus, in our view, it is logical for it to be heard after those topics. Mr. President, to the last point, we have no other submissions regarding the hearing sequencing for other topics within the scope of case 002/02. However, we do have a final submission in relation to sequencing, and this relates to two witnesses we have requested to be heard at trial. As we have noted in our updated witness list, that is document number E305/4.1, our requested witness, 2 TCW 923, he is 96 years old, while our requested witness 2 TCW 946 is 80 years old. And given their advanced age, we request that these two witnesses to be the very first witnesses to be heard at trial, and that, if necessary, their testimony be given via audiovisual link. So these two witnesses are not necessarily related to the sequencing of the order, but because of their advanced age, we would like to see them as the exception to the proposed sequencing of the trial. Thank you very much.
President, thank you, Councillor Victor Coupe. And Madam Council for Kisampon, you may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. I would like to start with the points on which we agree with Nuncia's defense team. That is, that we should effectively start with the issue of the armed conflict and end with the role of the accused for the reasons that he has given. And we find that a logical approach because it will enable us to use all the evidence adduced under those two subjects regarding the sequence within those two subjects. We would like the Chamber to respect the order of the closing order. That is, we have cooperatives and work sites, followed by security centers, followed by measures targeting specific groups with the population movements, which was another aspect but which is coherent. And lastly, regulation of marriages. Let me point out that regarding cooperatives and work sites, dealing with this at the very beginning of the trial after armed conflicts is very logical. After we will have ended with 002/1, we talked about movement of populations and then proceeded to cooperatives. And we followed a chronological order with, as far as the administration of evidence is concerned. This is a more well-adapted approach. So we also endorse the points developed by Mr. Coupe, that is, armed conflict is essential as we discuss the various topics in case 002/02.
Thank you, Council. The trial chamber would like now to invite the co-prosecutors and the lead co-lawyers to respond to the defense's submissions. They each have 15 minutes to provide their responses. And first, I'd like to give the floor to the prosecution. You may proceed.
Thank you, Mr. President, and good morning, Your Honours. In his introductory remarks, Mr. President referred to the need to ensure the coherence of the trial structure and the need for that structure to be clear and logical. It's our proposal that the request by the co-prosecutors, and as largely supported by the civil parties, presents such a clear and coherent structure. And I'll explain that in brief terms before I respond to the defence's proposed changes. As the President indicated, we've proposed that the trial be conducted by way of a series of segments, for want of a better term, commencing with the role of the accused, within which the court would deal with allegations relating to S21, internal purges and roles of the accused. And can I say, generally speaking, that approach in dealing with broad issues that affect the entire case is consistent with the trial chamber's management of the first trial. As to why S21 is included by us and I suspect by our learned friends, the counsel for the civil parties in that group, is simply because S21, as we have submitted on many occasions, is the most representative criminal crime site in this case as far as the allegations of the joint criminal enterprise with respect to the targeting of enemies are concerned. Of course, it also relates very much to the roles of the accused, both Nuon Chea and Khieu Samphan. This was a crime site, we allege, and the closing order alleges, established by the party centre, and a crime site, the leadership of which reported directly to the party centre. It received prisoners from the entire country and from all administrative, civilian and military structures of the Khmer Rouge. Here I'm, of course, paraphrasing the allegations in the closing order. To deal with internal purges and roles of the accused within that same topic in our submission provides a clear foundation and a basis for an understanding, at least at that point, of the joint criminal enterprise, and to then build on that with the second segment, which, as Mr. President indicated, covers 3 security centres, Krang Tachan, Okan Seng, and Nom Krau. In our submission, it is then logical to move on to the issue of the targeting of specific groups, the Vietnamese and Chams, before turning to a separate policy which deals with the operation of cooperatives and work sites, those being the 1st January Dam, Trapang Ma Dam, and the Kampong Chnan Airport. And following that, we have submitted that forced marriage charges should be heard, given that they relate to allegations on a nationwide basis, and are therefore conducive to a separate hearing of evidence on that issue. And of course, we propose to conclude the trial with overview or expert witnesses. Turning to the defence's proposal that the international armed conflict evidence be heard first, can I say initially that, of course, evidence of the international armed conflict will be heard throughout this trial. That is of necessity because, pursuant to the trial chamber's severance order, grave breaches of the Geneva Conventions form part of this trial, and the specific crime sites in relation to which grave breaches have been charged include S21 and Okan Seng Security Centre. So, in a way, by following the order which we are proposing, Your Honours will in part also address the defence's wishes that the issue of international armed conflict or evidence on that issue be considered. We don't think it's useful to have a separate phase of the trial in which evidence only of the international armed conflict is heard, because that international armed conflict, whilst very significant, doesn't form the core theme of this case, certainly on any view of the indictment. Can I remind everyone that pursuant to Rule 87(1), the prosecution bears the onus of proof in relation to all charges. And so whilst we note, of course, that it is for the trial chamber to determine the order in which evidence is heard, we implore the trial chamber to follow the proposal we have set out and to enable us to present the evidence against the indictment in a manner in which we say it's most conducive to the ascertainment of the truth. We don't believe that hearing cherry-picked sites as diverse as genocide of Vietnamese Chams and a work site is conducive, particularly not at the start of the trial, to a broader understanding of the charges and the evidence. And the same remarks I would make in relation to hearing roles of the accused last. The trial chamber, in our view, wisely decided to hear first evidence relating to authority structures, communications and roles of the accused in the first trial, and the same logic should follow. Nothing of what my learned friends have said really compels Your Honours to do differently. Can I turn to the issue of the two witnesses that my learned friend Mr. Koppe asked be heard first? The prosecution does not oppose this request. The trial chamber has in the past prioritised the hearing of witnesses which are elderly or whose appearance may become difficult as the trial unfolds. So provided the trial chamber accepts that the evidence proposed from those witnesses is relevant and conducive to ascertaining the truth, we have no objection in particular to them being scheduled in the early stages of the trial. And lastly, can I make one practical request while I'm on my feet of the trial chamber? In the first trial, the chamber generally proceeded by way of providing advanced lists of witnesses to the parties in each segment of the trial. We think that approach is sound, and we would encourage the chamber, as far as is possible, to consider and make decisions on witnesses to be heard for each segment in stages, to hear the parties on any further requests that may arise, and to then inform the parties of the witnesses to be heard for each segment. So my proposal of the prosecution is that you make decisions on witness selection in segments and then inform parties of your decisions, hopefully with sufficient time for everyone to prepare. Mr. President, unless I can assist you further, those would be my submissions in response.
President, thank you. You may be seated, and allow now to give the floor to the lead co-lawyers.
Merci, Monsieur le Président.
Thank you, Mr. President. Just one brief remark regarding the introductory statement made by my colleague Ang Pik. I want to be clear because the interpretation of what I said in Khmer and in English wasn't very clear. We wish to support the proposal by the Office of the Prosecutor regarding the sequencing of the trial. We are aware of the fact that the prosecution has a burden of proof, and it's therefore up to them to choose the procedure which is as appropriate as possible to them as possible. That wasn't clear in the translation I heard in English. Regarding the last proposal by my learned colleague of the prosecution, we also support the motion that the chamber should proceed one segment at a time for each list of witnesses. And as we proceed in that manner, we would wish that the chamber should decide on which civil parties which are most relevant, and they can ask that the testimonies of those witnesses be revisited, given the probative value of the evidence they provide, and this will determine which witnesses and civil parties should be brought before this trial. That would be the most relevant and the most useful approach.
Thank you, and Bạch Ong, you may proceed. Bạch Ong. And once again, good morning, Mr. President and Your Honors. I apologize if my previous statement is unclear, but I believe it has been clarified by my international counterpart on the order of trial as proposed by the co-prosecutors as they are the initiator of the case. And the remarks made by the defense teams, in particular in their request to hear in the order of the facts presented in the closing order, in our view, that is not necessary. What is important is that what we can manage so that the trial can be more effective. And in their submission to start with the armed conflict first, it is our view that that fact is to be started first. It would disrupt the time and the flow of the proceedings, as other parties, for instance, our lead co-lawyer section, to make such a request to hear our civil parties' testimonies or other facts. And for that reason, the order of the trial cannot be efficient. And as stated by my learned counsel, the prosecutor, the armed conflict issue will be heard throughout the segments of the trial, as this issue is interlinked with other facts. In their submission by Nunchi's defense on the hearing of the advanced age of the witnesses, I believe that is appropriate, as we can start with the advanced age witnesses. And likewise, the civil parties who have an advanced age shall be heard at the beginning of the trial. These are my submissions, Your Honor, and thank you. President, thank you. The trial chamber will decide as soon as possible upon the order of the trial proceedings and will issue a written decision in due course. Before turning to a brief review of the list of potential witnesses, civil parties, and experts, the Chamber would like to provide a brief update on the filing of the list of documents and exhibits. On 8 April 2014, the parties were ordered to file an updated list of documents and exhibits they intend to produce in case 002/02, that is document E305. And on the 8th of May 2014, the Nunchi's defense team notified the Chamber that since it did not submit original list of documents and exhibits pursuant to the Chamber's order to file material in preparation for trial in 2011, it is unable to update any such list. That is document E305/3. The co-prosecutors, civil party lead co-lawyers, and key support defense team all filed updated list in pursuant to the trial chamber's order, That is document E305/13, E305/14, and E305/12, respectively. In these filings, the parties have indicated that they will offer the Chamber several thousand documents during the case 002/02 proceedings. The trial chamber is currently reviewing this list. It appears that several documents were not previously included in the parties' original list. The Chamber again reminds the parties that they must apply under Internal Rule 87.4 for the inclusion of these documents in case 002/02 in accordance with the Chamber's previous ruling. That is document E305 and E307/1. On 24 July 2014, the Nunchi defense team submitted list of new documents and exhibits. That is document E305/5. Turning now to the list of potential witnesses, civil parties, and experts submitted by the parties for case 002/02, the Chamber reminds the parties that they may apply for the hearing to enter closed session and that the discussion will otherwise continue with the use of the pseudonym provided to the parties on 24 July 2014. Each party shall have a maximum of 30 minutes to address the Chamber. It is for the parties to decide how they will allocate their time when addressing the following issues. The parties have so far proposed 88 civil parties, 20 experts, and 121 witnesses, totaling 229 individuals. That is document E305/4, E305/5, E305/6, and E305/7, respectively. Additionally, the co-prosecutors have proposed 36 further reserve witnesses. In view of the cumulative size of the parties' list and the length of time it would take to hear these individuals, the Chamber invites the parties to discuss a possible reduction of their list. The trial chamber takes this opportunity to again remind the parties of their obligation to ensure that their submissions, including Internal Rule 87.4 requests for the submission of new evidence at trial, are made in a diligent and timely fashion. On 24 July 2014, the Nunchi's defense team submitted list of new individuals, that is 5 witnesses and 1 expert, to be heard at trial. That is document E307/4. On the afternoon of 28 July, the co-prosecutors filed a Rule 87.4 motion regarding their proposed witnesses, civil parties, and experts who were not included in their initial list for case 002 filed in 2011, document E307/3/2. This filing comes 80 days after the co-prosecutors filed their updated list of proposed witnesses, civil parties, and experts, and 2 days before this hearing. The Chamber's preliminary reaction is that such a filing is very late indeed, and probably too late to be addressed fully at this hearing. The co-prosecutors have withdrawn 7 witnesses from their recently updated witness list for case 002/02. They seek to substitute 3 of them with 1 reserve witness and another witness from their 2011 list. They also seek to add 1 more individual to their case 002/02 list. The lead co-lawyers submitted for filing their Rule 87(4) motion only yesterday afternoon. The Chamber has been obliged to remind the parties constantly that all steps taken in preparation for trial, including the provision of recent submissions in support of requests for the inclusion of new evidence, must be completed in a timely manner. If they are not, the parties risk delaying the commencement or the smooth progress of case 002/02. The Chamber invites the parties, if they wish to do so, to provide oral responses to the co-prosecutors' Rule 87(4) motion, but notes that if they do not avail themselves for this opportunity, any written responses to the motion should be filed in accordance with the internal rules. Given the timing of their filing, the lead co-lawyer's motion is yet to be notified to all parties at the time of the commencement of this hearing, and therefore no oral responses will be sought to this motion. Any written responses should be filed in accordance with the internal rules. Next, an issue arises pertaining to a request for protective measures. The co-lead lawyers for the civil parties initially included Civil Party 2, TCCP 238, previously TCCP 19, as a civil party for whom protective measures were sought. However, they have since indicated that protective measures are no longer necessary and have rescinded their request for protective measures. That is in document E305/7/2. The Chamber observes that the submission of unsubstantiated requests for protective measures impact upon the preparation for case 002/02, using both resources and time. The Chamber reminds the parties of the necessity of ensuring that such requests are substantiated and that they may liaise with the witness and expert support unit to discuss any general matter, including the protective measures framework applicable to the Tribunal. The trial chamber trusts that in future all parties will comply with their professional obligations. The trial chamber will provide the other parties with an opportunity to object to the inclusion of Civil Party 2, TCCP 238. The Chamber notes that the co-prosecutors have also proposed to hear this individual. Finally, the Chamber invites the parties to comment on the objections to the list raised by the Kirstenpon's defense team, that is document E305/9, and the National Co-Prosecutor, document E305/10. The other parties did not avail themselves of the opportunity to comment on the updated witness, civil parties, and experts list. The Chamber will also consider the objections raised by the accused and party defense team to certain individuals proposed in the co-prosecutors' updated list and their argument that they do not have sufficient information in respect of the certain individuals and the scopes of the trial to assess the proposed witnesses, civil parties, and experts. The Chamber invites the other parties to make submission on the accused and party defense team's position before according the accused and party defense time to respond. The trial chamber now invites the parties to comment on these issues. And first, we would like to give the floor to the prosecution. You may proceed.
Thank you, Your Honor. I'll briefly address some general issues and then turn it over to my colleague, Mr. Boyle, to address the specific objections. Your Honor, one point I'd like to make is that what we've tried to do in all of our filings is to assist the trial chamber to select the witnesses and the documents that are most conducive to determining the truth. In this case, each of the parties have worked on this case for years, and as time goes on, as we've heard evidence, as we've seen documents, we have a better understanding, and I'm sure that's true of Your Honors also, of the issues and the evidence. And also, some witnesses who were available previously are no longer available. So we have tried to diligently respond to all of Your Honor's orders, including the 11th June order regarding the new witnesses in filing our responses and motions. In relation to documents that were not on the list in 2011, it's our view and our hope that Your Honors would consider those when the parties attempt to present the documents to the court, whether or not there is a justification or compliance with 87-4. And I will say this on behalf of the prosecution. In relation to any witness or document proposed by any of the other parties, we will not object in any case because a document wasn't on the 2011 list. We don't feel that we're prejudiced if it wasn't on a 2011 list, as long as we have sufficient notice now of the witness or document. We also took to heart and considered carefully Your Honor's request that all of the parties consider a reduction in the witnesses. We understand the need to make this trial as efficient as possible. Again, that's why we've tried to concentrate on selecting those witnesses and documents we now believe are most relevant. We reviewed all of the evidence, and as Your Honor just mentioned, we dropped several witnesses from our proposed list just in the last few days in our recent filing. And we now have proposed 123 witnesses. However, most of these are crime-based witnesses, and we have estimated that the testimony of all of these witnesses would take approximately 118 court days. Given that the prosecution bears the burden of proof to prove all of the elements of each crime alleged, at each site alleged, beyond a reasonable doubt, we have selected what we feel is the minimum number of witnesses that we can be assured we would meet that burden. And we've cut out many witnesses we would like to call, but trying to make it reach a minimal number of those sufficient to meet the burden of proof. So, unfortunately, at this time, we cannot cut any further witnesses. There is a possibility as the trial evolves, and even after we read the judgment from case 0201, we may have a slightly different view of which witnesses are essential, and if so, we will certainly notify Your Honors. And Mr. Boyle will address other issues.
Good morning, Mr. President. I'd like to thank the Chamber for the opportunity to respond to the objections raised by the Q Sampan defense in E3059 against some of the witnesses, experts, and civil parties proposed by the co-prosecutors. I will be responding to some of the objections raised by the Q Sampan defense, and my colleague Liang Seng will respond to the remainder. I will begin by responding to broader categories of objections raised by the defense before moving on to responding to objections to particular individuals. At paragraphs 18 to 27 of the Q Sampan filing, the defense object provisionally to witnesses and civil parties for whom the parties do not yet have access to all of their statements. In addition to the witnesses identified by the Q Sampan defense in that filing, the co-prosecutors note that yesterday the Chamber and the parties were notified of the prosecutor's filing E307-32. Co-prosecutors Rule 87-4, motion regarding proposed trial witnesses for case 002/02, in which the co-prosecutors identified certain proposed witnesses for whom additional statements were obtained in the Case 3 or Case 4 investigations. As further described at paragraphs 19 to 22 of that filing, the co-prosecutors have requested permission to disclose these statements to the trial chamber and the parties in Case 2. But thus far, the Office of the Co-Investigating Judges has not yet granted us permission to do so because of concerns about the ongoing investigations in those cases. The co-prosecutors submit that the trial chamber should defer ruling on whether to call the affected witnesses and civil parties until such a time as all of the individuals' relevant statements are available to both the trial chamber and the parties. The co-prosecutors also note, however, that since the Q Sampan defense filed their objections in May 2014, the co-prosecutors have uploaded a number of documents to the shared materials drive, including many statements by proposed prosecution witnesses, thereby giving the defense access to these statements. The co-prosecutors informed the chamber and the parties that these documents were available on the shared materials drive by email on 30th June 2014. I will now move on to address the Q Sampan objections at paragraphs 39 and 40 of E305/9 to 3 expert witnesses and 1 reserve expert witness proposed by the co-prosecutors. These experts are 2 TCE 85, 2 TCE 86, 2 TCE 88, and 2 TCE 89. The co-prosecutors first note that the defense's objections in these paragraphs are not to the admissibility of these experts, but to the weight the chamber might ascribe to any testimony they provide. The defense argue that these experts would not be impartial, and therefore their testimony should be afforded little weight because they were previously affiliated with or worked for organizations focusing on the Khmer Rouge, or because they previously worked for certain offices within the ECCC. Notwithstanding that the Q Sampan defense do not, in this section of their filing, object to the admission of these experts, the co-prosecutors make the following brief observations. First, the co-prosecutors observe that this chamber in E215, titled Decision on Assignment of Experts of 5 July 2012, stated at paragraph 15, quote, "The mere fact that an expert witness has a previous association with an external organization does not disqualify him or her from being called as an expert," end quote. And this chamber decided at paragraph 17 of that decision to consider any specific and reasoned challenges to an expert's testimony arising from the expert's affiliation with an external organization when evaluating the evidence. Second, in relation to an expert's prior employment by offices of the ECCC, the co-prosecutors note that in E283, titled Decision on Designation of TCE 33 of 26 April 2013, where the trial chamber was considering defense objections to calling Stephen Heder as an expert witness in case 002/01, both the Nuonchea and Khieu Samphan defense objected to calling Stephen Heder as an expert, arguing that he could be neither independent nor impartial because he had previously worked for the Office of the Co-Prosecutors and for the Office of the Co-Investigating Judges. This chamber, at paragraph 15 of that decision, adopted the reasoning of the ICTY Appeals Chamber and decided to call Mr. Heder as an expert, noting that any issues of impartiality could be explored while the witness was on the stand, and that the chamber would assess the weight to attribute to the expert's testimony in light of all of the submissions made regarding the expert. The co-prosecutors submit that these proposed experts, should they be called, would provide highly valuable evidence to this chamber as it searches for the truth in case 2/2, and should they be called, would provide their testimony as experts consistent with their oaths and obligations to provide information with the utmost neutrality and objectivity. Next, I will address the objections of the Khieu Samphan defense at paragraphs 49 and 50 of E305/9 to the expert witness and reserve expert witness the co-prosecutors placed under the title Overview in their proposed witness, expert, and civil party list. The co-prosecutors proposed 2 TCE 85 and as a reserve 2 TCE 89 in that section. The co-prosecutors first note that the defense have not made arguments objecting to calling these witnesses based on these experts, based on the particular evidence they would or would not be able to provide, or based on their qualifications. But rather, they object based on a claim that calling an expert that can testify on a number of different areas would be repetitive and therefore wasteful of the court's resources. The co-prosecutor's explanation of the experience, knowledge, and expertise these individuals would bring to the chamber, which was included in the co-prosecutor's witness list, makes clear that these experts will provide valuable evidence that is not repetitive of evidence provided by other witnesses, experts, or civil parties. Moreover, the co-prosecutor's decision not to place these experts under any one issue or crime site's heading is indicative of the wide variety of areas and issues on which they would provide valuable information to the trial chamber. The breadth of those areas is further reflected in the specific points of the indictment they would be qualified to provide evidence on, as identified in the co-prosecutor's witness list. Indeed, calling one expert witness who would be able to address so many points is not repetitive, but efficient. And it is because the expert's testimony would be conducive to ascertaining the truth across such a broad range of issues that the co-prosecutors propose they testify at the end of the trial, when that testimony could draw together the evidence in disparate areas already presented. At this time, following on the President's invitation earlier, I would like to propose that we go into closed session to discuss the remainder of the Q Sampan defense objections in order to more clearly address the objections to particular individuals without revealing their identity through circumstantial information.
The President. Could the prosecutor enlighten the chamber of its justification for your request?
Yes, Mr. President. We believe that for the remaining 4 individuals whom the Q Sampan defense have objected to, and which we would like to respond on, certain details in the discussion of those objections could potentially, despite the use of pseudonyms, reveal who those individuals are. And so out of an abundance of caution, we propose to go into closed session. However, should the chamber prefer to continue in open session, we will, of course, do so to the best of our ability.
The President. I hand over to Judge Civil Cartwright. Judge, please proceed.
Thank you, President. The Chamber wishes to ask for one clarification of your submission that it ought to go into closed session to discuss the remaining witnesses proposed by the Kyo Sampan defence. We simply wish to know if there are any issues concerning protective measures for these 4 witnesses. Thank you.
Judge Cartwright, just to clarify on the premise, these are responses to objections that the Q Sampan defense have made to individuals proposed by the co-prosecutors, and there are no protective measure issues in effect.
How about the defense team for Kiew Sampon? Do you have any observation to make concerning the request by the co-prosecutor for the closed session for the 4 witnesses in the list of witnesses proposed by the prosecutors? Mr. Kung Samon, thank you, Mr. President, and good morning again, Your Honors. The request by the co-prosecutor to enter into a closed session, I don't think that it is necessary because those witnesses have their pseudonym given by the trial chamber. So the limitation of the discussion may be confined to the things that can be discussed or heard in public. And I don't think that, again, this request should be entertained. Thank you. The President, thank you. The Chamber would now like to rule on the request by the prosecutor, requesting that we proceed to a closed session to hear the 4 witnesses. The Chamber does not grant this request because it does not have any effect on the protective measure, and in addition, the trial chamber has given pseudonym to individuals proposed, so we should proceed to discuss them based on this basis. Now, the prosecutor can resume your observation.
Thank you, Mr. President. Before I turn the floor over to my colleague, Liang Seng, I will briefly address the defense's objection to the calling of 2 TCCP 237, which, they argue, would be wasteful of the court's resources. The co-prosecutors submit that 2 TCCP 237, who has been proposed by both the civil parties and the co-prosecutors to appear in Case 2/2, has valuable, unique, and extremely detailed evidence to provide regarding the acts and conduct of the accused that otherwise would not be admissible due to the operation of this Chamber's decision on evidence of the acts and conduct of the accused. Additionally, since 2 TCCP 237's renewed indication to the lead co-lawyers that he wishes to provide evidence in Case 2-2 and is not seeking protective measures, the Witness and Expert Support Unit has contacted the civil party by phone and confirmed these facts, as indicated by document E29/461 of 9 June 2014. Therefore, the co-prosecutors request that the Chamber call this civil party to provide evidence because he has important information to offer on the roles of the accused. He has clarified that he is not seeking protective measures, and therefore there is no reason not to summon this civil party to provide evidence. Thank you, Mr. President. I will now turn the floor over to Mr. Seng Liang to continue our response to the objections.
First of all, good morning, Mr. President. Good morning, Your Honors. And good morning to everyone. I would like to respond to 3 witnesses and experts objected by the defense counsel for Kiew Sampon. And these witnesses and experts, I would like to call them 1, TC2, TCE82, and 1 more expert, 2 TCE95, and witness expert, another witness expert, TCE 93. To begin with, I would like to discuss T2TC E82, document D268/3.1, E3/3416. The defense for Khieu Sampon argue concerning the summoning of this individual witness is that she is not qualified as an expert. She does not have concrete research methodology in relation to her book entitled Gender-Based Violence During the Democratic Cambodia period, and that sources of data collection is not reliable. If we look at the legal framework applicable before the court, as well as the Cambodian law and international practice, she has not demonstrated her qualification, or there is no criteria for the judgment of the credibility of anyone to be an expert witness. The former in Onan and Talik case dated the 3rd of June 2003, and Garlic case on the 2nd of July 2002 ruled that in order to be qualified as an expert, there must be provision concerning training as well as qualification, so that that expert can explain the issue at stake. Therefore, the argument raised by the Defense Counsel T2TC E82, who does not possess a PhD degree, is not necessary. What is important is that she will assist this chamber mobilizing her specialized skill in order to make the event easy to understand, particularly the application of policy on forced marriage and rape in that context. Her book, written within the context of gender-based violence or sexual violence at that period, is very important and relevant to the charges brought against the accused. As for the issue raised concerning the case before us, she interviewed some 700 people. She conducted an interview with 100 persons directly, and the staff from the Defenders Project. And she also interviewed with 600 other individuals, with 200 students conducted interview with the other witnesses under her direct supervision, and those students were from Panyasastra University. And her study in 2006, which was her first study, it was comprehensive and thorough concerning the forced marriage under the Khmer Rouge regime. If we look at the substance of the argument of the Defense Counsel concerning the methodology of her research for TCE 82, they argue that it lacks professionalism and it does not demonstrate a very clear methodology, and they also question the standard of the research. As for the question concerning the reliability of data collection, by comparison, use to the unreliability is unsubstantiated, and the necessity of the work depends on the management of the author. And for this reason, I believe that it is important that the person be summoned by the court and clarify on her research. For the question concerning the reliability of this particular expert is not well substantiated. For TCE 82, she has been working for 17 years and she has understood the education system in Cambodia very well. She has been a lecturer in universities. She has published numbers of documents concerning gender issue in Cambodia. This manifests the fact that she is one of the respected experts in relation to research as well as the methodology in conducting interview with witnesses, together with the conclusion she draw from the research. And she has published a number of other documents concerning other issues in relation to gender issue. And aside from the publication of the gender-based violence during the Khmer Rouge regime back in 2010. Other than gender issue in Cambodia, she has been a lecturer, a guest lecturer at Panyasastra University, and she has been a consultant on gender issue with Ministry of Women Affairs in Cambodia. Of course, TCE 82 is not the only expert who can enlighten the court on the gender-based violence during the Khmer Rouge regime. That's why the prosecutor has not objected to the defense counsel for Khieu Samphan requesting the chamber to summon another expert to testify concerning the forced marriage during the Khmer Rouge regime. Indeed, the two experts have focused on two different areas, and they also based on different rationale and sources of data. But these two witnesses are very crucial to enlighten and shed light for this court concerning the forced marriage, the rape, and the policy of the Democratic Cambodia concerning marriage. Now I would like to raise another issue which defense team for Khieu Samphan has objected against 2 TCW95. This document, this witness, document E3/1822, E3/2653. This witness was originally proposed by the Office of Co-Prosecutor because the publication concerning the commission of crimes and treatment of Cham during the Democratic Cambodia period. This research is relevant and it provides a direct account of crime against humanity as well as genocide against Cham ethnicity. The defense counsel argues based on two grounds. One is the qualification and educational background, because they say that this particular witness has no qualification necessary to testify on this issue. And secondly, this person is the victim and also the witness of the Democratic Cambodia. And she used to work with the Documentation Center of Cambodia, and now she is also one of the staff members of the Office of Co-Investigating Judges. Of course, the two books have received from the witness 2CEW95. They provide sufficient information concerning the treatment of Cham ethnicity during the Democratic Cambodia. What is important is that this book provides information concerning the witnesses and documents concerning the treatment of the Cham by the Khmer Rouge from 1970, and it also describes the rebellion of the Cham ethnicity, the forced evacuation of Cham, the execution and massacre of Cham in Kruchma in 1978, the execution of Cham group in S21, as well as the estimation of Cham executed under the policy of the Khmer Rouge. The research that leads to the publication of the two books on the execution of Cham was included in the list of documents in K02, and we believe that this is the credential that confirm that the witnesses and experts are qualified to testify on this issue, and I am sure that these individuals will shed light for the chamber concerning this fact. And I believe that these are the victims who are the researcher on Cham ethnicity, and also the person who conducted investigation, and there has been argument that this person will be biased in providing expert testimony. But let us look at the previous ruling of the chamber, which decided that the protest concerning the impartiality and the independence of witness is an issue that is relevant to the weight to be given to the evidence. It is not. It has nothing to do with the admissibility of the document. Now I would like to turn to the objection by the defense counsel for Khieu Sampon against another expert witness, TCE 93. She is one of the witnesses proposed by the co-prosecutor and Nuon Chea defense team. She was proposed to testify on the demographic statistics, particularly concerning the people who died during the Khmer Rouge regime, in particular the Vietnamese and Cham. Witness 2 TCW93, according to the defense counsel, has no knowledge or experience to testify before this chamber. Now, if we look at her previous training and education concerning demography, obviously it is clear that she has been dedicated her entire life profession into this demographic study. She studied econometrics, and she has a master's degree in econometrics and a PhD in demographic. And she worked in the ICTY, in the Office of Court Prosecutor over there, since 2010. And before that, she used to work with the national demographic situation in the Netherlands for some 6 years, and she published a report, academic journal, a discussion paper, as well as dissertation and other analytical paper, and she has sufficient experience in analyzing particular demographic issue. And the expert 2 TCE 93 has demonstrated this issue in her report entitled Victims of the Khmer Rouge Regime in Cambodia from April 1975 to January 1979. Document E3 2413. The objection on the article authored by her concerning the demographic study that is based on the European experience that does not mobilize her skill to conduct the study in demographic situation in other part of the world. Actually, this objection failed to look at the fact that certain experts have received sufficient experience and training, and they are flexible and good enough to adjust to situation in other places. So TCE 93 experts and research is clear that she has sufficient experience and qualified enough to mobilize her skill to apply in the various contexts relating to the facts before the chamber. The objection that the comments of the expert to TCE 93 have been criticized in other fields which people may not find it reliable. That was due to the different view expressed by this individual. The chamber of the ICTY court have thus far rejected certain comments by the expert due to the reliability of the research methodology they have employed. Even those in case CIMIC, the chamber objected the expert comment, but in Perlich and Hugon, the chamber accepted her finding. And Luki case, which was also referred to by the Defense Counsel, actually the chamber accepted her view, which was cited by the in the ruling of the chamber. According to the report, that the expert will provide the testimony that Kyu Sampon defense team has not provided any explanation or justification that the view of the expert is not acceptable. I can think of my last response to the objection by the Defense Counsel that the expert to TCE 93 is biased due to the fact that she was once a staff member of the Office of Co-Prosecutor at ICTY. This was an issue to be decided on the weight to be given to the evidence, but the actual weight will be assessed based on her testimony in court at a later stage. For the foregoing reason, the Office of Co-Prosecutor would like to request the chamber that this expert be summoned to testify before this court. I am sure that these experts are very crucial to assist the court in ascertaining the truth throughout the evidentiary hearing. Thank you, Mr. President. Thank you, Mr. Prosecutor. The time is now appropriate for adjournment. The chamber shall adjourn now for lunch and resume at 1:30 this afternoon. Security guards are now instructed to take Mr. Kyu Sampon to the holding cell downstairs and have him return to this courtroom this afternoon before 1:30. The court is now adjourned.